Our next expert is Veronica York. Veronica is nationally recognized domestic violence, DV and child abuse custody expert. Her partner is Goldstein and York, which is Barry Goldstein, DV Experts, LLC, qualified in 10 states to provide expert testimony in domestic violence custody cases. Trained family law mediator, certified high conflict divorce coach, extensive experience educating courts, professionals, and communities on evidence-based research to protect children in high-risk custody situations. Expertise in impact of DV on children, adverse childhood experiences, which is ACE, research, U.S. Department of Justice Saunders study, primary attachment research, shared parenting, child sexual abuse, and gender bias in family court proceedings, misuse of parental alienation, my favorite annoying subject. Let me add the word syndrome. Let's say it together. Syndrome. And then coercive control and Darvo tactics. Everybody welcome Veronica York.
It is so nice to be here, and just having everyone together is wonderful. And thank you so much, Doctor, for the work you've done. And I know firsthand the retaliation that you get when you are an advocate, when you stand up for what's right. But we still do it because that's what we have to do for our children. So thank you for the introduction. Thank you everyone for being here. The first thing I want to do is just provide a little bit of context for the situation. I think that we're all in. We're going to hear a lot of your stories, and I think this context helps people understand who are outside of our bubble, who don't get it. Because even when I was outside of the bubble, I didn't get it. It wasn't until I became a victim of the family court system that I understood what was really going on. So there's two contexts. The first one is that most contested custody cases are handled amicably, settled out of court. You have two good, safe parents. There's a very small percentage, less than 4%, that require trial and all the other things that go along with that. And 75 to 90% of those cases are domestic violence and child abuse cases. So when courts are looking at all of their docket, they're seeing mostly cases where they can use standard court practices. These small percentage of domestic violence cases are different and have to be handled differently. And they don't understand that because they're not using evidence-based research when they are doing their cases. They're using the same old standard court practices that have been developed back in the 1970s when there was no research about domestic violence and child abuse. So with that context, we are looking at a very specific paradigm shift that needs to happen in family court, because I believe that judges don't want to hurt children, ultimately. Obviously, there are those that do. But for the most part, judges are trying to do what's best for children, but they do not have the tools, nor the knowledge, nor the expertise to do it. So as an expert witness coming in, I'm trying to provide them with the evidence-based research to help them do their jobs more efficiently, more effectively, and these cases can be settled or ruled on very quickly with this information. They don't have to drag on for decades and decades, but the problem is when we're appointing guardian ad litems, when we're appointing custody evaluators, parenting facilitators, all therapists, all the stuff, it's a money train, and they don't want that money train to stop. So we're dealing with that too. The other context I wanted to quickly provide is that 99% of these cases is that during the relationship, the father wanted or demanded the mother provide the majority of the child care. When the mother decides she's had enough of the abuse, she wants to report his abuse, she wants to leave, and she leaves the relationship, the father then says, she's crazy or she's alienating my children. And to the court system, that sounds like she's an unfit parent. But the reality is that the abuser is the unfit parent. And so that context is extremely important in family court because abusers are able to manipulate the court system because of that specific context. And so with research like ACE, she mentioned adverse childhood experiences, we can show courts that the well-being of the child should be the first priority, is the health and safety. And you can't do that without the ACE research, because the ACE research fundamentally says that children who are exposed to domestic violence and other trauma, like child abuse, will live shorter lives and face a lifetime of health and social problems. So your children are experiencing anxiety, depression, low self-esteem, suicide, all of these things because they've been exposed to domestic violence. And we are not talking about physical violence. Courts think domestic violence is physical violence, and on the criminal side, it can be. But in family court, it's the stress and fear that abusers cause. So that stress and fear is what we have to look at in family court and how that impacts the child. Because that stress and fear is what's going to ruin their lives. And courts don't get that. And so they're looking at all these best interest factors, and they are looking at, because they don't understand domestic violence, they're minimizing that impact, and they're looking at other factors that are just not as important as the child's health and safety. So we need to get that as the first priority. The Saunders study out of the U.S. Justice Department was a study that assessed the domestic violence knowledge of judges, lawyers, and evaluators. Because custody evaluators are the mental health professionals that courts rely on, depend on for information. And the problem is that custody evaluators do not have the specific knowledge and expertise needed to recognize and respond correctly to domestic violence and child abuse. So they're not screening for domestic violence. What they're doing is they're using psychological tests that are not telling us anything about domestic violence, and they're pretty much making abuse victims out to be the perpetrators, because again, abuse victims are going to have PTSD, they're going to have anxiety, they're going to have a lot of issues caused by the abuse. And so we need to understand that. And what Saunders is saying is that we need to have specific knowledge in 4 areas in these cases. So that does include screening for domestic violence. It includes risk assessment. It includes post-separation abuse, because abuse does not end when the relationship ends. They use the court system to continue that abuse. And you need the impact of domestic violence on children, which is ACE. So without that knowledge, the courts are using the wrong professionals and the wrong experts. So how can we protect children when we're not using the right experts? So as an expert in domestic violence, we want to create this multidisciplinary approach in family court. Honestly, you don't even need a custody evaluator. Custody evaluators are making things worse because a lot of them are proponents of the false and pseudoscience parental alienation syndrome. And what is really good parenting by a mother is looked at as parental alienation, because they're trying to protect their children from further abuse. And that parental alienation syndrome is being touted by fathers' rights groups, who are usually the abusers, who are trying to get across the 50-50. And as Francesca said earlier, shared parenting, the Saunders study specifically found that shared parenting is not appropriate in domestic violence cases for very obvious reasons. And when we impose things like shared parenting, what we're doing is we're giving the abuser all of the power, because there is an unequal balance of power, obviously, between an abuser and a victim. So shared parenting can never work in those cases. I'll briefly talk about gender bias, because in family court, I think the perception is that family court's biased against fathers, but the truth is, it's very biased against mothers. And the reason for that is that they're giving mothers less credibility. There is a study called the Bala study that says that mothers in contested custody cases make deliberate false reports less than 2% of the time. And courts are disbelieving mothers, particularly when they're accused of parental alienation, 98% of the time. So you can do the math and figure out that mothers are always they're biased against mothers, particularly when they report abuse. And because of that, they're holding women to a higher level of proof, standard of proof. They're giving women less credibility, and they're blaming them for the actions of their abusers. And of course, they take a mother's emotion and frustration and anger in dealing with her abuser all out of proportion to what it says about her parenting. So they're looking at basically her reaction, her normal reaction to the abuse, and calling her the actual perpetrator, which is part of DARVO. And I won't go to that, but that's deny. The abusers use that tactic. It's deny I'm the abuser, attack my victim, and then reverse victim and offender. So I will briefly say that in regards to shared parenting, I've been hearing from fathers' rights groups that Kentucky, which was the first state to implement the presumption of 50-50, they're touting the statistic that, divorces are way down in Kentucky because we have 50-50. Well, yeah, because you're making it much harder for victims of abuse to leave their abuser. Why would we leave our abuser if we can't protect our children from them? At least if we stay, then we can be there to protect them. So my advice to those fathers' rights groups is to take a look at the homicide rates in Kentucky and DV homicide rates to see if they're going up, because I guarantee that they are. They're going up in a lot of states because of these 50-50 presumptions. So I definitely wanted to point that out. The last thing I'm just going to talk about is that, as experts, we are really trying. I know there's a lot of talk about, courts educate. What do they need? Do they need education? Do we need to just, drop the whole system? I mean, yes, all the above, right? We need to do anything that we can to educate, to change the system, to get this act passed, to scream it to the rooftops, because we're dealing with, and we often compare what's going on in family court with what happened with big tobacco back in the 1960s when the Surgeon General's report came out and said, hey, tobacco links smoking and cancer. And with family court, the ACE research, we're linking adverse childhood experiences to diseases like cancer and heart disease. Because you know why? That stress and fear, if you think about it, if you go to the doctor and you have a heart problem, they're going to say you need to reduce your stress. We're putting children through all this stress, and it's causing them lifelong issues. The life expectancy of a child who's gone through this is 20 years less than a child that hasn't gone through the family court system and dealt with these adverse childhood experiences. So we really need to use our voices in every aspect of society, the medical profession, the legal profession, the education profession, media, all aspects of society need to come together just like we did with cancer and smoking to let everybody know this is a health risk, this is a problem, this is a major issue. And Barry and I, along with Dr. Motrice Hanna, have a book coming out later this year where we're talking about all of this and all aspects of society and how we can all help to prevent domestic violence and child abuse, and particularly in child custody cases, because that's where the majority of these children are suffering and being murdered because they're being sent to live with their abusers. Thank you so much.